On this episode of Law Weekly, we look again at the growing call for the establishment of the Electoral Offences Commission. We have the views of a senior legal practitioner, Jiti Ogunye. Also showing on the program, the 31st President of the Nigerian Bar Association, Senior Advocate of Nigeria, Yakubu Mekiel, speaks about the task ahead of his administration for the next 2 years, plus a recap of the top trending legal stories. Hello and welcome to the program. I am Shola Shuyeli. The Independent National Electoral Commission, INEC, has again made a case for the establishment of a new commission to deal with electoral offenders. At a public hearing organized by the House of Representatives Committee on Electoral Matters held on the 23rd of August in Abuja, to discuss the bill for an act to establish the National Electoral Offences Commission, the INEC chairman, Professor Mahmood Yakub, said work on the country's electoral process would remain incomplete if electoral offenders continue to walk freely.
INEC is saddled with the responsibility of prosecuting electoral offenders under the Electoral Act. This has been very challenging for the Commission. For instance, since the 2015 general election, 125 cases of electoral offenses were filed in various courts, out of which 60 convictions have so far been secured. So I recommend the establishment of the Electoral Offences Commission.
The Economic and Financial Crimes Commission, EFCC, on its part, has opposed the establishment of an Electoral Offence Commission, citing duplication of functions. The stance of the EFCC was delivered at the same public hearing by its assistant commandant.
Section 145 of the Electoral Act also have already given power, prosecutorial power, to the INEC to prosecute the criminal offenses. So it's our position that there's no need to create an agency solely for the purpose of investigating and prosecuting electoral offenses, most especially when our electoral processes is seasonal in nature.
To deepen the discussion and get further perspectives on this issue, I spoke to a senior legal practitioner, Jiti Ogunye, about the propriety of setting up a new commission and whether it's necessary. I want to talk about the issue of the establishment of the National Electoral Offences Commission. It's an issue that's been coming up again and again. I know that following the 2007 general elections, which a lot of people are judged as one of the worst elections in the history of the country, the federal government at the time set up the Justice Mohammed Uwais Electoral Reform Committee, which recommended a lot of reforms. And one of the key ones was for the establishment of this Electoral Offences Commission, which will arrest and prosecute electoral offenders. But you are a student of history. You take your time to do research into all of these issues which affect the majority of the people. I'm curious as to how you're reading this. Is it necessary? Because there have been arguments for and against whether we need an Electoral Offences Commission. Do you think that we really need one?
My take is that in spite of the plausibility and the force of the arguments on both sides of the aisle of the debate, my view is that we need first to situate the call for the establishment of an additional law enforcement agency within a schema, within a context. And that context first, which is the governance context, is that already the executive branch of government is littered, and I'm choosing my words carefully, with all sorts of agencies, bureaucracy upon bureaucracy, making governmental business unwieldy. In the law enforcement arena, we have the Nigeria Police Force. People are calling for the creation of state police, and there is an emerging consensus on that now, because the most critical opponents of state police in the past, including Olusegun Obasanjo and all those ultra federalists or centrists who were saying that the creation of state police will be abused. All of them now have moved full circle, including state governors and every other person, saying that given the crime rate in Nigeria, the rate of insecurity in Nigeria, that creating state police and devolving policing powers in Nigeria has become imperative. So we have the police force. We have the blue-shirted, it's mouthful, I don't know how to pronounce it, the NCDSC, but I'm not sure I got the acronym right. CDC, you know, we have that one. Indeed, in the past, there was going to be a Peace Corps with a lot of people that have been recruited already, you know, along that line. We have the DSS, we have the EFCC, we have the ICPC, we have the INEC, we have all sorts. So the question that has to be posed at a very basic level is that, do we need to create an additional bureaucracy? In spite of all that have been recommended, do we need to create an additional bureaucracy to deal specifically with the issue of electoral offenses, investigating these electoral offenses and prosecuting them? Do we need to create such an additional agency? My view is that we don't need to do that.
I want to come in here because I hear what you say about multiplicity, bureaucracy of agencies. Yes. But then the INEC that is saddled with this responsibility is the one at the forefront of even pushing for it, saying that they have so much, like you referenced, they have so much to do that they cannot cope with doing this. Isn't that a valid argument?
It's not a valid argument, and I will tell you why. INEC is a body that is created by law to deal with electoral matters in Nigeria. What the chairman of INEC, TwoYear, is now saying is that we are overburdened. Strip us of some of the powers that we have and then domicile these powers in another agency that you are going to create. Look at context again, vis-a-vis the job that has to be performed and the roles. Do you know the hefty, the humongous budget that is given to INEC every year, particularly in a national election year? Hundreds of billions of naira to deal with his job. Okay? And when he's giving that money, with the possibility that if another agency is created, there won't be a dent in the threshold or the budgetary allocation to INEC. What is he suggesting? What he's suggesting is that you create another body, you release more money to election matters. Election is only a vehicle. The destination is democracy and ultimately good governance and development. Democracy itself is not even a destination. The end of democracy is good government and all that. So the question is, what is the cost of this Nigerian democracy? What is the cost of just conducting election and then get people to power in our country in the face of dwindling revenue and monies that are available for development? So what he is saying is countered by the argument that, hey, what has happened to INEC creating a prosecution or a prosecution and investigation department?
So you think that the solution lies in them looking for an inside way within?
They have a legal department. Yes. The legal department farm out INEC briefs to external lawyers. So what they now need to do is to recruit more lawyers, create a prosecution department that will be saddled with the prosecution and all that. Exactly. Now, under the Electoral Act, currently, the Attorney General of the State and the Attorney General of the Federation have responsibility for prosecuting with INEC legal department, right? And there's also a provision that INEC could hire lawyers, could give briefs out for people to prosecute on his behalf or handle civil matter. What INEC needs to do now is to look at the cost of creating that unit. Now, before now, what we now know as the EFCC used to be called the anti-fraud unit of the police. And even after the EFCC was created, the police also, in competition now, created its own special fraud unit. Okay? So I'm saying that there are already institutions that can deal with this investigation. And indeed, what this man is now asking should be done is problematic. And it's going to cause a lot of problems. Look, when you create such a body at one level, the question of capacity will now come in. We have 36 states all over the country. So electoral offenses, notionally are committed across the states. This body will sit in Abuja. So the need to create zonal offices will then emerge. The need to create state offices will then... You have another behemoth, another octopus. For what? Just to arrest offenders every season, every 4 years. So after they've arrested them and prosecuted them, so what would they be doing in between? Those officers that are recruited to investigate and then prosecute them. So what would they be doing? So they'll be doing nothing in between elections. That is not a good reason to create another bureaucracy. Within INEC, create an investigation department, electoral offenses investigation department that will work with the police, or you ask police to be seconded there, experts to be seconded there and all that. Look at your law, existing law. If there are no sufficient provision, ask that it be amended to accommodate that investigation unit, then recruit lawyers to prosecute, and then they can then help you do this.
But wouldn't it ultimately still lead to more funding?
It may lead to more funding, but it will then lead to a situation whereby, like in some state of the Federation, for example, Ondo State. Because I want to make that example. Ondo State has about 3 universities now. That small state. The first civilian governor from 1999, Ade Farati, started one state in his village, which is now a town, Akoko. Agagu came, started another university in his village, or in Okutupupa. Mimiko came, created a university of medical science in Ondo. One state, 3, and you know what they do? Each of them has its bureaucracy, vice chancellor, registrar, and they fight to occupy these positions and all that, That was a state that had one state university before. When Ondo State, current Ondo State and Ekiti State were one state in Abeokuta, in Ado-Ekiti. So it's become job for the boys. It has nothing to do with quality of education. And if I was the governor of that state, I will make the 3 universities, I will merge it into one. Now, I think that what the NBA can do moving forward, setting the agenda, the first thing that it needs to do, because if you want to maintain an external relations, your domestic policy must be right. The Yoruba knows they say, "Lila think catch your road." So the NBA has a first task to heal itself before seeking to heal society. And by this I mean that I have observed that there are too many centrifugal tendencies in the NBA right now. Egbe Amofin, Midwest, Eastern Bloc, northern, wherever, we are going to create our own. Yes, and all that. There are too many of such things.
Welcome back. It's no more news that the 31st president of the Nigerian Bar Association has since assumed office. At his inaugural ceremony last Friday in Lagos, Senior Advocate of Nigeria Yakubu Mekiao said, among other things, that his administration will boldly confront all issues affecting the profession negatively, as well as issues confronting the nation.
There has not been any time in this country when Nigerians have looked more to the bar as they do now for a way out of the rather bleak situation, and they are certainly looking at the right direction. We are the ones, by privilege of our training and expertise, are positioned to ask the right questions, interrogate the system, and call those saddled with the responsibility of providing security for the lives and properties of Nigerians to account for their stewardship. Permit me to borrow from a biblical expression just how the entire country is looking up to us, and say that just as the entire world is eagerly waiting for the manifestation of the sons of God, so are Nigerians, and please listen to this. Nigerians are eagerly waiting for the discharge of the leadership responsibility and interventions of the members of the legal profession. We have what it takes to precipitate the leadership that will bring the succor and freedom Nigerians deserve, and we cannot afford to shirk from that responsibility. In the next couple of weeks and months, the NBA under my leadership will take steps and set in motion processes that will seek to interrogate government's investments in security of this nation and the utilization of these investments, if any, in order to ascertain reasons for what clearly appears to be a failure of national security. Our apparently ill-equipped security personnel are continually being sacrificed, notwithstanding what is known to be their patriotism, uncommon courage, military expertise, tact, zeal, gallantry, and determination to defend the Nigerian people, their properties, and territorial integrity of the nation. This engagement must be carried out expeditiously. It's necessary in order to, and amongst other things, generate discussions that will provide Nigerians with sufficient information to guide them in making their choice of persons who occupy elective offices in the upcoming general elections. Besides the need to guarantee the security of the lives and properties of Nigerians as they troop out to vote in the 2023 general elections, the ultimate outcome of the election will largely depend on the interface between the bench, the bar, and the political gladiators. As members of the legal profession serving either on the bench or at the bar, we owe Nigerians sincere and honest participation in the process. With respect to conferences, but let me start by saying that I promised in my manifesto that I would have Mr. President, past president, I'm not used, an additional 1,000 members to be onboarded on the NHIS scheme, following the 1,000 that we have on the pilot scheme. And we would pay for the subscription of those that are already onboarded when we will renew their subscription. And so, in the next 60 days, together with the elected officers, we'll put our heads together to come up with those 1,000 members from across the 125 branches, soon to become 128. 50% of this number will be spread between our colleagues of 1 to 7 years post-call. Not less than 100 will be drawn from our colleagues with physical challenges. The remaining will be distributed amongst other members based on the criteria to be agreed. We already have a criteria, a template. We would go back and look at them. If there are areas where we need to look at those ones, we will do the same thing. And then, so in line with that promise, what we intend to do, have an additional 1,000 the first year of my administration by the grace of God, another 1,000 in the second year of my administration, so that by the time we are exiting, we would have not less than 3,000. By the way, all of you members who can afford it can pay just 15,000 naira to get health insurance cover. With respect to conferences, because this administration considers attendance of conferences as part of continuing legal education, and we must continue to sustain that, this is what we are going to do. We will reduce the cost of conference fees It's too early to clap. Oh. Here, the initial offer. Lawyers of 1 to 5 post-call will pay 50% less the fee paid this year for the agency. On condition that such members are in good financial standing and have recorded not less than 70% participation in the CLE program of the Nigerian Bar Association. For avoidance of doubt, and you can hold us to it, this should come to 7,500 for the early bird, 20,000 for regular registration, and 40,000 for late registration. Similarly, similar provisions will in due course be made for other category of lawyers as our financial position improves. My administration views conferences and particularly the AGC as knowledge-sharing opportunities, and our younger colleagues must be encouraged to take advantage of every such opportunity. Colleagues that are physically challenged do not need to pay fees anymore.
And just before we go, a high court sitting in Jos, Plateau State, has discharged and acquitted a former governor of the state, Senator Jonah Jang, of alleged misappropriation of the sum of 6.3 billion naira. The court, presided over by Justice Christy Darbob in her judgment, discharged and acquitted Senator Jang and his co-defendants of all the 17 counts and held that the prosecution lacked evidence to prove the allegations against them. Let's now bring you a recap of some other top trending legal stories.
We begin with the report that the Federal High Court sitting in Abuja has dismissed a suit instituted by the Nigerian government seeking to extradite the suspended Deputy Commissioner of Police, DCP Abba Kyari, to the United States of America. Kyari is wanted in the U.S. over alleged conspiracy to commit wire fraud, money laundering, and identity theft. Justice Iang Eko, in his judgment, held that the extradition request filed by the Attorney General of the Federation on behalf of the Nigerian government lacked merit and was instituted in bad faith. The court also held that the federal government had no basis to file the extradition request, having commenced trial in the case filed against Mr. Kyari by the National Drug Law Enforcement Agency. Still in Abuja, another federal high court judge fixed September 14 to hear a suit by Governor Nyesom Wike of Rivers State against the People's Democratic Party and its presidential candidate Atiku Abubakar. Justice Ahmed Mohammed fixed the date after granting an application requesting for an extension of time. The application was filed by Priscilla Eje, the counsel for the PDP, Governor Aminu Tambuwal of Sokoto, and Mr. Atiku. There was no objection from Wilfred Okoye, the counsel representing Governor Wike, and his co-applicant, Prince Michael Ekamon. In the suit, Governor Wike is seeking, among other things, the court's order declaring him the PDP's presidential candidate for the 2023 election. He and his co-applicant are also asking the court to determine 8 issues, which includes whether the purported transfer of Tambuwal's votes to Atiku by the PDP was illegal and void. They are also asking the court to determine if Tambuwal lost his claim to votes the moment he stepped down for Atiku. Governor Wike has, however, recently denied filing any suit against the party and its presidential candidate. The same Justice Mohammed has ruled in favor of the Nigerian Bar Association, NBA, and held that despite a previous ruling, the application for a stay of execution was paramount and takes precedence over the interlocutory injunction filed by the suspended General Secretary, Mrs. Joyce Udua. Accordingly, the judge adjourned the case and fixed hearing for the application for September the 15th. The plaintiff, Mrs. Joyce Odua, who was present in court, is challenging her suspension from office after an emergency meeting held on August the 15th by the immediate past national officers of the NBA. The former officers had unanimously suspended Mrs. Odua from office after allegations of gross misconduct. The Federal High Court Abuja had, however, set aside the ratification of the suspension as done by the National Executive Council of the NBA. And we round up with a report that 2 students of the Nigerian Law School Enugu State campus who were abducted by gunmen have been released. The 2 students, identified as Chukwuemeka and Festus Pedro, were said to have been abducted around 8 p.m. at Eke Market in Agban in Kano West local government area of Enugu State on August the 17th this year. They were reported to have gone to the market area to buy food before they were ambushed by the gunmen. A few days after, the gunmen made a demand of 50 million naira as ransom before they would be released from captivity. The students were, however, released after spending 8 days in captivity. There are indications that their family members paid an unspecified amount as ransom.
And that's the program this week. Please feel free to share your thoughts on any of the content we featured today. If you missed any part of it, you can find the video and past episodes on our YouTube channel. I'm Shola Shoyeli. Thank you for watching and see you next week.